Everyday Samurai, Episode 70. Greetings, friends, and welcome to Everyday Samurai, in service to your liberty and the security of a free state. How do you do? Today we are pushing forward with our annotated reading of By Tyranny Out of Necessity, The Bastardy of Martial Law by Dr. Edwin Vieira. Starting with Chapter 7, Martial Law Precluded by the Laws of Nature and of Nature's God. The Declaration of Independence not only explicitly denounced such martial law as was known in its own time, and therefore must be taken to discountenance the far more oppressive martial governance which threatens Americans in the present era, but also provided conclusive evidence that no authority which existed outside of the Declaration, but to which it was arguably subject, countenanced martial law as it operated even in the founding era, or could conceivably approve of or even acquiesce in martial governance as it is being promoted today. The only authorities which the Declaration explicitly recognized and to which it subordinated itself and the good people on whose behalf it spoke were the laws of nature and of nature's God. On the basis of those laws and of those laws alone, the Declaration asserted the right of Americans to assume among the powers of the earth the separate and equal station to which they were entitled. The laws of nature and of nature's God entitled Americans to that station in the sense of giving them a claim to it by their possession of suitable qualifications, which they established by determining for themselves that the government of Great Britain had become destructive of the ends for which all proper governments are instituted among men, by withdrawing the consent of the governed from the government, by successfully throwing off such government and providing new guards for the people's future security, and then by exercising their right to be free and independent states, possessed of full power to do all acts and things which independent states may of right do. To justify this course of action, the Declaration excoriated martial law in particular and in detail, condemning it as part of a long train of abuses and usurpations, pursuing invariably the same object which evinced a design to reduce the people under absolute despotism. Therefore, inasmuch as martial law supplied a complex of serious grievances which entitled the good people of the colonies to invoke a right as against Great Britain under the laws of nature and of nature's God, martial law could not possibly have been consistent with those laws, but instead must have constituted an absolute wrong inflicted upon Americans in that era, and because the laws of nature and of nature's God have not changed since 1776, will constitute no less of a wrong inflicted upon any among we the people against whom it may be applied today. Moreover, if those laws recognize degrees of illegality in this particular, then martial governance in the present era must be even more intolerable than was martial law in the founders' time, when Americans were actual subjects of the British Empire. For under the English Constitution, although disfavored, martial law imposed upon civilians was perhaps to some degree licit, whereas today our system of government clearly is the antithesis of total military rule. The military should always be kept in subjection to the laws of the country to which it belongs, and he is no friend to the republic who advocates the contrary. The established principle of every free people is that the law shall alone govern, and to it the military must always yield. And therein ends Chapter 7. With this, it is important to remember that your training in an armed martial art is part of a civic duty. It's not just a hobby. It's not just something you do for fitness, but particularly with consideration of samurai-related martial arts, where edged weapons engagement is the focus. There are directly translatable skills that you can contribute towards the public good. This is why comprehensive martial arts like those of the samurai that incorporate mind, body, and spirit are not just for selfish endeavors, but something that you provide to everyone around you, including executing the laws of the Union in the instance of your own case. And in such a society where these responsibilities are taken seriously, the amount of crime and corruption would be certainly reduced, and the ability of the political caste, that is, the politicians, the bureaucrats, and the oligarchs that are pulling the strings behind the scenes, would have very little opportunity to impose martial law. Keep that in mind as we proceed now with Chapter 8. Chapter 8. Martial law incapable of being rationalized under color of the law of nations. At the present time, martial law and its most extreme expression in martial governance find the source of their supposed legitimacy in the law of nations, so-called international law, and in particular in the law of war and the international law of belligerent occupation. The Declaration of Independence, of course, appealed to the laws of nature and of nature's God, not to any law of nations or law of war as the source of the authority of the good people of the colonies to publish and declare that the United Colonies are and of right ought to be free and independent states. Indeed, nothing could be clearer on that score than the Declaration's explicit appeal to the supreme judge of the world for the rectitude of our intentions. Yet, the Declaration also observed that a decent respect to the opinions of mankind required that Americans should declare the causes which impel them to the separation from Great Britain, and that facts should be submitted to a candid world in order to prove that the history of King George III is a history of repeated injuries and usurpations, all having in direct object the establishment of an absolute tyranny over these states. In its deference to the views of other nations and peoples and its solicitation of their sympathy, the Declaration might lead a careless reader to imagine that the good people were indirectly appealing to some sort of international legal authority or consensus with the apparent force of law that is the law of nations, which would have held that the catalogue of the king's repeated injuries and usurpations justified Americans' action. The question might then arise whether this law of nations could, under some circumstances, supplement or even override the laws of nature and of nature's God, such that, perforce of the Declaration, the Constitution of the United States could draw upon it or even be subordinated to it. The answer to that question must be no. But analysis is necessary in order to fully understand why this is so. The first step must be to examine the fundamental distinction and thereby understand the relationship between the laws of nature and of nature's God and the law of nations, as Americans in the founding era understood the matter. As Blackstone explained, law, in its most general and comprehensive sense, signifies a rule of action, and it is that rule of action which is prescribed by some superior, and which the inferior is bound to obey. Man, considered as a creature, must necessarily be subject to the laws of his creator, for he is entirely a dependent being, and consequently it is necessary that he should in all points conform to his Maker's will. This will of his Maker is called the law of nature. For when God created man and endued him with free will to conduct himself in all parts of life, he laid down certain immutable laws of human nature whereby that free will is in some degree regulated and restrained, and gave him also the faculty of reason to discover the purport of those laws. As he is a being of infinite wisdom, the Creator has laid down only such laws as were founded in those relations of justice that existed in the nature of things antecedent to any positive precept. These are the eternal immutable laws of good and evil to which the Creator himself in all his dispensations conformed, and which he has enabled human reason to discover, so far as they are necessary for the conduct of human action. As the Creator is a being of infinite goodness, he has been pleased to contrive the constitution and frame of humanity that we should want no other prompter to inquire after and pursue the rule of right, but only our own self-love, that universal principle of action. For he has so intimately connected, so inseparably interwoven the laws of eternal justice with the happiness of each individual, that the latter cannot be attained but by observing the former. And if the former be punctually obeyed, it cannot but induce the latter. This is the foundation of what we call ethics, or natural law. For the several articles into which it is branched in our systems amount to no more than demonstrating that this or that action tends to man's real happiness, and therefore very justly concluding that the performance of it is a part of the law of nature, or, on the other hand, that this or that action is destructive of man's real happiness, and therefore that the law of nature forbids it. This law of nature is, of course, superior in obligation to any other. It is binding all over the globe, in all countries, and at all times. No human laws are of any validity if contrary to this, and such of them as are valid derive all their force and all their authority, mediately or immediately, from this original. But in order to apply this to the particular exigencies of each individual, it is still necessary to have recourse to reason, whose office it is to discover what the law of nature directs in every circumstance of life, by considering what method will tend the most effectually to our own substantial happiness. But every man now finds that his reason is corrupt, and his understanding full of ignorance and error. This has given manifold occasion for the benign interposition of divine providence. The doctrines thus delivered we call the revealed or divine law. These precepts are found upon comparison to be really a part of the original law of nature, as they tend in all their consequences to man's felicity. Upon these two foundations, the law of nature and the law of revelation, depend all human laws. That is to say, no human laws should be suffered to contradict these. There is, it is true, a great number of indifferent points in which both the divine law and the natural leave a man at his own liberty, but which are found necessary for the benefit of society to be restrained within certain limits. And herein it is that human laws have their greatest force and efficacy. For, with regard to such points as are not indifferent, human laws are only declaratory of and act in subordination to the former. Although the laws of nations derive from the law of nature, the two are nevertheless in important aspects distinct one from the other. As Blackstone observed, if man were to live in a state of nature unconnected with other individuals, there would be no occasion for any other laws than the law of nature and the law of God, but man was formed for society. However, as it is impossible for the whole race of mankind to be united in one great society, they must necessarily divide into many, and form separate states, commonwealths, and nations, entirely independent of each other, and yet liable to a mutual intercourse. Hence arises a third kind of law to regulate this mutual intercourse, called the law of nations, which, as none of these states will acknowledge a superiority in the other, cannot be dictated by either, but depends entirely upon the rules of natural law, or upon mutual compacts, treaties, leagues, and agreements between these several communities, in the construction also of which compacts we have no other rule to resort to but the law of nature, being the only one to which both communities are equally subject, and therefore the civil law very justly observes that quod naturalis ratio inter omnes homines constituit vacatur gentium. The law of nations is a system of rules, deducible by natural reason and established by universal consent among the civilized inhabitants of the world in order to decide all disputes, to regulate all ceremonies and civilities, and to ensure the observance of justice and good faith in that intercourse which must frequently occur. But the law of nature, being the only one to which both communities are equally subject, and therefore the civil law, very justly observe that here he goes into a Latin phrase which is translated as what natural reason establishes among all men is called the law of nations. The law of nations is a system of rules deducible by natural reason and established by universal consent among the civilized inhabitants of the world, in order to decide all disputes, to regulate all ceremonies and civilities, and to ensure the observance of justice and good faith in that intercourse which must frequently occur between two or more independent states, and the individuals belonging to each. This general law is founded upon this principle, that different nations ought in time of peace to do one another all the good they can, and in time of war as little harm as possible, without prejudice to their own real interests. I think that should apply to individuals as well. And as none of these states will allow a superiority in the other, therefore neither can dictate or prescribe the rules of this law to the rest. But such rules must necessarily result from those principles of natural justice, in which all the learned of every nation agree, or they will depend upon mutual compacts or treaties between the respective communities, in the construction of which there is also no judge to resort to, but the law of nature and reason, being the only one in which all the contracting parties are equally conversant, and to which they are equally subject. And you can see there, in order to have law, there must be reason, there must be rationality, and there must be rules upon which people agree. And it's hard to do that in the spur of the moment. Therefore, it's good to talk about these things frequently, early, and often, so as to prevent conflict. Thomas Rutherford was another well-respected commentator on the law during the pre-constitutional period, and he made clear all nations are obliged to observe the law of nature, but this obligation gives them no positive legislative power over one another. It does not give any one nation or any number of nations authority to bind the rest, either to do anything which the law of nature has not enjoined, or to avoid anything which this law has not forbidden. But though for want of a social union, and consequently of a legislative power, amongst the several nations of the world, there cannot be any positive law of nations, yet the law of nations may be distinguished from the law of nature, and the foundations of this distinction is laid in general agreement and positive institution. This general act of consent is the foundation of the law of nations, as far as this law differs from the law of nature. The matter of both these laws is the same. The law of nations, as well as the law of nature, commands whatever is beneficial and forbids whatever is hurtful to mankind in general. But whilst the matter of them is the same, the objects of them are different. The law of nature considers mankind as individual persons. The law of nations considers them as formed in collective persons. Thus, the same law, which is called the law of nature, when it is applied to separate and unconnected individuals, is called the law of nations. When it is applied to the collective bodies of civil societies, the law of nature. In this application of it, is not the only measure of the obligations that nations may be under towards one another. They become capable of binding themselves to one another by particular compacts or treaties to do or to avoid what the law of nature has neither commanded nor forbidden. But these obligations arise from immediate and direct consent, and extend no further than to those nations that by their own act have made themselves parties to them. The law of nations is the law of nature, applied by positive consent, and consequently the dictates of it are only the dictates of right reason, and may be collected by arguing from the nature of things, and from the condition and circumstances of mankind. The history of what has passed from time to time amongst the several nations of the world may be of some use in this inquiry, because we shall there find what has been generally approved, and what has been generally condemned, in the variable and contradictory practice of nations. From hence we may see what use is to be made of the judgment and testimony of skillful persons in these inquiries. Their judgment will help to point out the law of nations, because what is approved of by men of prudence and honesty and experience is more likely to be comfortable to the dictates of right reason than what is approved of only by the vulgar and unthinking and dissolute. Thus it is apparent that in its appeal to the laws of nature and of nature's God, the Declaration of Independence did not invoke some idiosyncratic notion of America's founders, but instead relied upon the long-standing principle of Anglo-American law, stated by Blackstone that upon these two foundations, the law of nature and the law of revelation, depend all human laws. That is to say, no human laws should be suffered to contradict these. Just as the law of nature's God is no matter of human choice or agreement, so too is the law of nature. For as Blackstone taught, the law of nature consists of the eternal, immutable laws of good and evil, which human reason is able to discover, so far as they are necessary for the conduct of human action. This law of nature is, of course, superior in obligation to any other. It is binding all over the globe in all countries and at all times. No human laws are of any validity if contrary to this, and such of them as are valid derive all their force and all their authority immediately or immediately from this original. So when the Declaration of Independence appealed to the law of nature, it asserted the absolute wrong of martial law, the absolute privilege of Americans to assume among the powers of the earth a separate and equal station, and their absolute right in that newfound station to do all acts and things which independent states may of right do. Distinguishably, the Declaration of Independence never once referred or needed to refer to the law of nations because, as Blackstone taught, the law of nations arises out of universal consent among the civilized inhabitants of the world, and the Declaration sought no such consent, only understanding, sympathy, and perhaps support from other nations. Yes, think about that. Civilized inhabitants of the world should be able to understand the basics of law and ethics, because as my friend and great author Saifuddin Ammous describes, if you give up the right of private property, we are just regressing back to the law of the jungle, and we might as well be monkeys throwing feces at each other. Civilized people respect private property, and that also includes the free exchange thereof. Any violation of the property integrity principle is simply an abandonment of reason. And once you abandon reason and principle, it becomes a war of all against all. Every warrior should be very cognizant of these principles so as to avoid conflict and to do the job of protecting people and their property, which is the whole purpose of law, which fosters peace and a high-trust society, and the evolution of consciousness as well as living standards through voluntary transactions and trade and innovation and entrepreneurship and greater service. So the Declaration of Independence is simply a restatement of principle for the law of nations as well as that which is applicable to individuals and individuals within community and societies. Involvement of Americans with other nations under the law of nations could only follow their becoming citizens of their own free and independent states. In the final analysis, however, that involvement too, whenever it might have arisen, would have been subject to the selfsame principles of the law of nature, to which the Declaration appealed. For as Blackstone explained, the rules of the law of nations must result from these principles of natural justice, in which all the learned of every nation agree, and they will depend upon mutual compacts or treaties, in the construction of which there is also no judge to resort to, but the law of nature and reason. That is, in America's founding era, as well as today, the law of nations was and is not separate from or independent of the law of nature, but was and remains an inextricable and utterly dependent consequence of that law. In particular, the law of nations is a system of rules deducible by natural reason and established by universal consent among the civilized inhabitants of the world in order to ensure the observance of justice and good faith. Nations are capable of binding themselves to one another by particular compacts or treaties to do or to avoid what the law of nature has neither commanded nor forbidden. So the law of nations will depend upon mutual compacts or treaties between the respective communities, in the construction of which there is also no judge to resort to, but the law of nature and reason being the only one in which all the contracting parties are equally conversant, and to which they are equally subject. That's one of the basics of all contracts, that those that enter into them have to understand the terms. They need to be clear, and they need to be voluntary. But that also obliges those that are entering into a contract to understand those terms and to stipulate definitions so that everyone that is party to that contract can comprehend all the ramifications thereof, which then leads to the further question about the worthiness of those people that you're interacting with. As Richard Mayberry describes, do not invest in chaos stand. There are those people that have never understood throughout their history these very basic principles of justice. Do all you have agreed to do. Do not encroach upon other people or their property. There are issues with relative IQ and the ability of certain cultures to comprehend basic principles of justice. So one must be selective about who they enter into contracts with and who they allow into their community. The general act of consent is the foundation of the law of nations, and as far as this law differs from the law of nature, the matter of both of these laws is the same. The law of nations, as well as the law of nature, commands whatever is beneficial and forbids whatever is hurtful to mankind in general. Thus, the law of nations is the law of nature, applied by positive consent, and consequently the dictates of it are only the dictates of right reason. In addition, the law of nations depends entirely upon the rules of natural law, or upon mutual compacts, treaties, leagues, and agreements between these several communities, in the construction of which compacts we have no other rule to resort to but the law of nature. Therefore, far from being in any sense disconnected from, let alone superior to, the law of nature, the law of nations derives from, and from that reason must adhere strictly to that law. Mutual compacts, treaties, leagues, and agreements between the several communities of mankind cannot disregard, let alone contravene, the law of nature, because all true governments are the creatures of that law, and therefore lack any authority to violate it either directly or indirectly, by commission or omission, and whether acting alone or in concert with others. As the equally eminent commentator in the pre-constitutional era, Emer summarized the matter, the law of nations is originally no other than the law of nature applied to nations. We call that the necessary law of nations, which consists in the application of the law of nature to nations. It is necessary because nations are absolutely bound to observe it. The law contains the precepts prescribed by the law of nature to states, on whom that law is not less obligatory than on individuals, since states are composed of men, their resolutions are taken by men, and the law of nature is binding on all men, under whatever relation they act. Since therefore the necessary law of nations consists in the application of the law of nature to states, which law is immutable, as being founded in the nature of things, and particularly on the nature of man, it follows that the necessary law of nations is immutable. Whence, as this law is immutable and the obligations that arise from it necessary and indispensable, nations can neither make any changes in it by their conventions, dispense with it in their conduct, nor reciprocally release each other from the observance of it. This is the principle by which we may distinguish lawful conventions or treaties from those that are not lawful, and innocent and rational customs from those that are unjust or censurable. Especially today, though, the problematic aspect of the law of nations is the presumption of universal consent among the civilized inhabitants of the world, who actually desire to ensure the observance of justice and good faith among themselves. The binding quality of the law of nature does not depend upon anyone's consent, and adherence to that law is the most convincing proof of any society's being civilized. Take a note of that. Adherence to that law, the law of nature, is the most convincing proof of any society being civilized. Those that do not understand natural law cannot be called civilized. In contrast, the consent requisite for emergence of the law of nations among various peoples, nations, and states may not be universal, either because the parties are not equally civilized, or because, although claiming to be such, they are nevertheless not equally intent upon the observance of justice and good faith in dealing with each other. Again, apply this to universal standards of justice, not within just the laws of nature, but also between the existing paradigm of political relations. Just as a single nation can be riven by factions, that is, a number of citizens, whether amounting to a majority or minority of that whole, who are united and actuated by some common impulse of passion or of interest, adverse to the rights of other citizens or to the permanent and aggregate interest of the community, so too can a supposed community of independent nations be beset with factionalism. And when factions predominate in such a community by dint either of numbers or of power, the ostensible law of nations, which emerges from their mutual compacts, treaties, leagues, and agreements, will almost surely be at odds with the principles of natural justice and the dictates of right reason. In 1776, the law of nations was, or was taken to be, coincident, or at least consistent with, the laws of nature and of nature's God. So when the Declaration of Independence condemned British martial law as repugnant to those laws, it implicitly condemned it as violative of the law of nations as well, to the extent that the law of nations applied to the internecine conflict between patriots and loyalists, and had Americans theretofore assumed among the powers of the earth a separate and equal station, the Declaration or whatever document would have performed its office under those circumstances could, should, and undoubtedly would have condemned British martial law explicitly on that ground too. Since 1776, the laws of nature and of nature's God have not changed of their own force in either substance or authority. Neither could they have been changed through any merely human agency. For as Blackstone observed, the law of nature is superior in obligation to any other. It is binding all over the globe, in all countries, and at all times, and no human laws are of any validity if contrary to it. And inasmuch as, according to Blackstone, the law of nations is a system of rules deducible by natural reason and established by universal consent among the civilized inhabitants of the world, one hopes that the principles which define civilization have not changed, except perhaps for better since then. Therefore, because, as Rutherford thought, the law of nations at any time is the law of nature at all times, the martial law which the Declaration of Independence rightfully excoriated, then must be no illicit now, under both the laws of nature and of nature's God and the true law of nations. And martial governance today being potentially even more oppressive than was martial law in the founding era, martial governance must be no less illegal under both corporis juris. Most importantly, the Declaration of Independence further teaches that even had British martial law been arguably consistent with what passed for the law of nations in that era, Americans were not therefore bound to acquiesce in it to their own enslavement forever after. For the Declaration was not based upon, controlled by, or in any sense subordinated to the putative law of nations, but instead recognized and followed as its sole authorities the laws of nature and of nature's God, which were then and always and everywhere remain absolutely superior to any law of nation. Neither would Americans today be bound to acquiesce in what paraded as the law of nations should it purport to contradict the laws of nature and of nature's God. There are many very good reasons for this. 1. According to Blackstone, the law of nations is a system of rules deducible by natural reason and established by universal consent among the civilized inhabitants of the world in order to ensure the observance of justice and good faith. And this general law is founded upon the principle that different nations ought in time of peace do to one another all the good they can, and in time of war as little harm as possible, without prejudice to their own real interest. That is, the true law of nations presumes that civilized peoples, properly applying natural reason in good faith, will agree on principles of international cooperation beneficial to them all, which principles will faithfully embody and apply the laws of nature and of nature's God. Furthermore, as Rutherford observed, the history of what has passed from time to time amongst the several nations of the world may be of some use in this inquiry, because we shall there find what has been generally approved and what has been generally condemned in the variable and contradictory practice of nations. From hence we may see what use to be made of the judgment and testimony of skillful persons in these inquiries. Their judgment will help to point out the law of nations, because what is approved of by men of prudence and honesty and experience is more likely to be comfortable to the dictates of right reason than what is approved of only by the vulgar and unthinking and dissolute. And just to break away and make a comment that all war is based on deception. The current war is summed up by the prevailing philosophy of socialism, which is institutional hostility to private property and the free exchange thereof. So they are vulgar and unthinking and dissolute when applying that standard of universal justice under a socialist commonwealth. It simply can't exist. There must be an oligarchy. There must be panels, Soviets, or fasces. Basically, it's a society that is governed by bureaucracy, and bureaucrats and the boards that they occupy get to dictate who gets to own what, or what type of property transfers and development is allowed, to include consumption. It's a world that is devoid of entrepreneurship because the board gets to decide how people will employ their resources, how they will exchange and develop technologies, and they cannot apply universal standards of reason and justice because they have to reserve to themselves exclusive privileges over other people's property. So do not expect to have any prudence or honesty in any type of reasoned argument with the socialist. And in fact, they will deploy all sorts of devious schemes to try and convince you that what they are doing is right, but it simply cannot be done in a forthright fashion, and expect all sorts of deception operations to undermine the very notion of truth. Moving on. 2. Today, martial governance can be said to arise out of and to apply the law of war and the international law of belligerent occupation. And the law of war is said to derive from two principal sources, namely, law-making treaties or conventions, and custom, although some of the law of war has not been incorporated in any treaty or convention to which the United States is a party. This body of unwritten or customary law is firmly established by the custom of nations and well defined by recognized authorities on international law. Evidence of the customary law of war arising from the general consent of states may be found in judicial decisions, the writings of jurists, diplomatic correspondence, and other documentary material concerning the practice of states. So even in the absence of relevant treaties, the parties to a conflict shall remain bound to fulfill their obligations by virtue of the principles of the law of nations, and as they result from the usages established among civilized peoples, from the laws of humanity, and the dictates of the public conscience. In theory, the unwritten or customary law of war is binding upon all nations. The customary law of war is part of the law of the United States, and insofar as it is not inconsistent with any treaty to which this country is a party, or with a controlling executive or legislative act, is binding upon the United States, citizens of the United States, and other persons serving this country. But what if the custom of other nations turns out to be simply irreconcilable with the principles of the Declaration of Independence, and those other laws of America's free and independent states, the authority of which derives from it, such as the Constitution? The Declaration looked to the law of nature as then understood, its presumption being that among civilized peoples, the law of nations would, and in most instances probably did, strictly comport with that law as then understood. But the 19th and especially the 20th centuries, and so far the 21st century too, have demonstrated in sad chronicles of death, destruction, and depravity that even supposedly civilized peoples can behave in the most barbaric fashions under cover of governmental policy, reason of state, military necessity, emergency, or some other double talk. Here also, Dr. Vieira references Rudolf Hump Rummel, death by government, genocide, and mass murder in the 20th century. Professor Rummel was at the University of Hawaii and did tremendous research into the concept of democide, which is governmental death of a people outside of war. It's really worth looking into. The wars of the 20th century, especially the First and Second World Wars, have exposed the modern law of nations as largely fictional, if not farcical, with respect to the basic supposition, as expressed by Blackstone, that different nations ought in time of peace to do one another all the good they can, and in time of war as little harm as possible, without prejudice to their own real interests. For these conflicts were cynically plotted and brought to maturity in times of peace, and then waged with immeasurable barbarity in times of war, for the very purpose, or at least with the inexorable and inevitable effect of breaking up Western civilization by prostrating one European nation after another. Surely it is impossible to square with any rational conception of civilization such atrocities as the targeting of civilians and destruction of vast cities by indiscriminate incendiary bombing, let alone the use of atomic bombs, the leveling of whole regions through scorched earth tactics, deportations and resettlements of entire populations, and other forms of ethnic cleansing, mass looting, rapine, and torture, the establishment of internment, slave labor, and death camp, and the installation of murderous totalitarian regimes, according to Stalin's dictum that the military occupation of a territory inevitably results as well in the imposition of the occupant's political, economic, and social systems, especially when the mass of a country's citizenry, along with its ostensible natural leaders, become aware of these crimes and then complicitous in and at least morally responsible for them through acts of commission or omission. Thus, historically verified time and again is that what may pass for the law of nations just as with any purely human law, may actually contradict the laws of nature and of nature's God, and intentionally so, because rogue officials simply refuse to follow those laws. Therefore, today one must turn Rutherford's statements into questions and ask what use is to be made of the judgment and testimony of such skillful persons as posture as experts with regard to the law of nations. Will their judgments help to point out the law of nations as it should exist? What if these skillful persons are skillful precisely as apologists and propagandists for usurpation, tyranny, aggression, genocide, and the like? What if these skillful persons are not, after all, men of prudence and honesty and experience, whose opinions are likely to be comfortable to the dictates of right and reason, but instead turn out to be the vulgar and unthinking and dissolute, the dishonest and even the psychopathic? And what if what has been generally approved by such skillful persons as to the variable and contradictory practice of nations proves to be manifestly evil according to the laws of nature and of nature's God? 4. Undeniably, Stalin's Soviet Union, Hitler's Germany, and Mao's China were anything but civilized regimes with respect to their international relations, as well as their domestic policy. They all openly repudiated the laws of nature and of nature's God in no uncertain terms, in both lying words and horrific deeds. So, any ostensible law of nations bottom upon a consensus among them, and similar totalitarian states could not have even pretense to conform with those laws, and therefore could never have qualified as a true law of nations. Totalitarianism of that stripe is not an aberration confined to the 20th century, however. Although philosophically dead, it remains all too alive politically even today, a species of the undead keen to sink its vampiric fangs into the throats of any people foolish enough to admit its adepts into their national councils. In addition, many countries in the contemporary world find themselves under the heels of actual barbarians, utterly unlearned in the principles of civilization. And in other countries which claim to be civilized, both public officials and much of the citizenry treat truth as simply whatever party line advances their self-interest, so that no mutual understanding is possible between them and those peoples who still believe that truth is not just situational and relative, but instead mirrors objective realities, which all peoples must acknowledge. I'll break for a simple comment that cooperation among people is exactly what civilization is all about. However, in order to ensure harmony in a society, that realm of inclusion needs to be restricted. Not to say that people should be summarily dismissed or looked upon with extreme prejudice, but people tend to find affinity with others that they share some common features with. And yes, that might include race preferences. So they're just like in Japanese society, there is a strong recognition of in-group versus out-group, and the way that you behave among people within your chosen in-group is very different from those of the out-group. Customs of courtesy and hospitality notwithstanding, which should be universal to everyone, but at the same time, you are more guarded with someone who is from outside of your particular social group. And the same should be true with politics. Do you really want to share a political affiliation with people that are not civilized? And how do you come to know and trust your neighbors to ensure that they understand the principles of civilization, that they abide by the laws of nature and of nature's God? Well, you get to know them through training, and that's what the militia ideal is all about. You get to know them because you train with them regularly. You see them at church or at school, but also at the dojo or at the shooting range or at the gym. You participate with them in basic community projects, mostly focused on securing a free state, whether that be executing the laws, repelling invasions, or suppressing insurrections, or the training and preparations thereof. You get to know who your neighbors are and what their character is, and you come to facilitate understanding through that process of training, expressing leadership and followership. All the things that go into working together and training together builds camaraderie and builds community and builds resilience. But that's exactly what those holding political power, despite their responsibilities for organizing, arming, and disciplining the population, seek to do the complete opposite. They want people dumbed down, drugged up, and distracted, and fighting amongst themselves over triviality, rather than focusing on the important functions of securing a free state, including securing a free state against the corrupt actions of public officials. Moving on. If states organized and operated on the principle of anti-civilization should make up a majority of all the states in the world today, or even if every state except the United States were such a state, could a law of nations as enunciated by a majority or even unanimity among them possibly qualify as the law of nations? Could the United States, still adhering to the laws of nature and of nature's God, as the Declaration of Independence requires them to do, possibly subscribe by any treaty, compact, or other agreement to, or in any other manner become bound by, or even recognize as legitimate such a pretended because perverse law of nation? In particular, if international misconceptions of the law of war, the international law of belligerent occupation, and martial governance violated the laws of nature and of nature's God, could the armed forces of the United States and the paramilitarized law enforcement agencies of the states invoke these foreign laws in order to set aside this country's own law, such as that the armed forces would in effect become the enforcers of the collective judgment of foreign states, the political conceptions of which were not only false but also inimical to those we the people held, as well as to those which every civilized society should hold? Hardly. No pretended or even actual law of nations can automatically preempt America's laws. Rather, any law of nations must be proven to be consistent with the political philosophy underlying American law before it can be treated as any kind of law at all in this country. As long as America's laws are coincident with the laws of nature and of nature's God, as the Declaration of Independence and the Constitution require them to be, but some or all of an ostensible law of nations is not, then the former must disregard, overrule, or absolutely negate the latter. Even if an aberrant law of nations violative of the laws of nature and of nature's God should be embodied in international custom, which had received the approbation of rogue officials in the general government, America's fundamental laws would take precedent. For were such customs controlling, America would no longer enjoy the separate and equal station among the powers of the earth to which the laws of nature and of nature's God entitled her, and her Constitution would not remain the supreme law of the land. That rogue officials might somehow have purported to accept customs of that ilk, such that the United States, along with other nations, were on record as agreeing in form to those barbarities, would prove nothing, or officials' acceptance of international customs repugnant to the laws of nature and of nature's God would be ultra vires and inoperative, on the grounds that no official could be authorized under the Declaration of Independence or the Constitution to violate those laws by adhering to international customs at odds with them. Similarly, even if rogue officials adhered to such customs through what appeared to be formal treaties, their actions would be nugatory in law, for no treaty can override the Constitution, let alone the Declaration of Independence, because any valid treaty must conform to the Constitution, because the Constitution must adhere to the principles of the Declaration, in particular, that governments derive only just powers from the consent of the governed, because the Declaration appeals to and embodies the principles of the laws of nature and of nature's God, and because the law of nations is supposed to conform in every particular to those laws, any treaty by dint of which the United States agree to be bound by some part of the laws of nations must be fully consistent with American law. 5. Therefore, if rogue officials employing martial governance under color of the law of nations, or of such of its subsets as the law of war, or the international law of belligerent occupation, should try to strip Americans of the separate and equal station among the powers of the earth, which the laws of nature and of nature's God entitle them, if they should attempt by word or deed to deny that governments are instituted among men for the sole purpose of securing certain unalienable rights, among which are life, liberty, and the pursuit of happiness, if they should purport to withhold from the good people their right to be free and independent states, if they should claim that the good people were no longer sovereigns in their own land, with full power to levy war, conclude peace, contract alliances, establish commerce, and to do all other acts and things which independent states may of right do, if they should invoke martial law similar to what King George III and his ministers put into effect, and especially if they should venture to set aside the Constitution in favor of martial governance in any form or under any rubric, by supposedly recognizing common Americans as belligerents and imposing military government on occupied territories within the states, then each of these actions, and certainly any combination of them, would finally confirm that the form of government then in the hands of those rogue officials had become destructive of the ends for which governments are instituted among men, deriving their just powers from the consent of the governed. Whatever powers those officials purported to exercise for such purposes would be exposed as unjust power within the understanding of the Declaration of Independence, and the applications of such powers would constitute abuses and usurpations, evincing a design to reduce the people under absolute despotism, and thus as serious a set of political crimes as could be committed against the laws of nature and of nature's God. Moreover, no American would be obliged morally, politically, or legally to acquiesce in any purported statute, regulation, executive order, judicial or administrative decision, or other putative official command which aimed at any such illicit end. And that is the end of Chapter 8, so we will pick up in Chapter 9 with the next episode. Friends, we hope you've enjoyed this episode of Everyday Samurai and look forward to seeing you next time. If you like what you've heard here, please share the show with a friend. Give us a like and a review on your podcatcher of choice, and visit Shop.EverydaySamurai.Life for other material in this same vein. You enjoy this type of political and economic analysis, then you will also like my book, The End of Gun Control, which you can pick up at Shop.EverydaySamurai.Life or visit theendofguncontrol.com. Until next time, stay sharp, stay aware, and be well.